Hey everyone, Cash here. Welcome back if you've been here before, and if this is your first time visiting our channel, welcome. In today's episode, we'll explore the legal facets governing the rental landscape. Buckle up as we navigate through crucial details for both tenants and landlords alike. Courtroom Showdown, the security deposit dispute in the court of Judge Judy Justice.
Your Honor, I am here today because my landlord, Mr. Smith, wrongfully withheld a portion of my security deposit. I left the property in excellent condition, and I expect a fair return of my hard-earned money.
Your Honor, Sarah's definition of excellent condition is questionable. The property was far from what I would consider acceptable. There were damages beyond normal wear and tear.
Normal wear and tear, Your Honor, exactly. I'm not responsible for every little scuff that happened over time. Mr. Smith is just trying to keep my money unjustly.
Unjustly? Sarah, you failed to address several issues during your tenancy and now you expect a full refund?
I promptly reported any issues, and I have photographic evidence that the property was in good shape when I left. Mr. Smith is exaggerating the damages.
Exaggerating? Your Honor, I have receipts for repairs and cleaning that were necessary due to Sarah's neglect. I even had to hire a professional cleaner.
Those receipts are inflated, Your Honor. I bet he hired a luxury cleaning service and charged me for it.
Order in the court. Both of you need to present your evidence. Mr. Smith, provide those receipts. Sarah, show your photographic evidence.
As the evidence unfolds, the courtroom drama intensifies. Will Sarah get her money back, or will Mr. Smith prove the damages were beyond normal wear and tear? This overview offers a broad understanding of common principles and statutes related to landlord-tenant security deposit disputes in the United States, as they might apply to the hypothetical case between Sarah and Mr. Smith. However, it's important to note the following. Disclaimer: Mac Empires does not provide legal advice. The information presented here is for informational purposes only and should not be construed as legal advice. The laws and regulations concerning landlord-tenant relationships, including those pertaining to security deposits, can vary greatly by state and locality. For specific legal advice or information regarding laws in a particular area, individuals should consult a qualified legal professional or local legal resources. Legal situations are often complex and require personalized advice and guidance from licensed attorneys who are fully informed about the specifics of a case. Tenant Sarah moved out of a rental property owned by landlord Mr. Smith after the completion of a one-year lease. Upon vacating the premises, Sarah expected the return of her entire security deposit. However, landlord Mr. Smith deducted a significant amount from the deposit for cleaning and repairs, alleging damages beyond normal wear and tear. In Michigan, security deposit disputes between landlords and tenants are governed by statutes under the Michigan Security Deposit Act, MSDA, specifically under MCL 554.601 to 554.616. Sarah filed a lawsuit against Mr. Smith, arguing that the deductions were excessive and unjustified. She claimed that the property was maintained reasonably during her tenancy and the deductions were not warranted. Many states have laws that limit the amount a landlord can charge for a security deposit. For example, in California, it's typically limited to 2 months' rent for an unfurnished property, California Civil Code Section 1950.5. Landlords are usually allowed to withhold portions of the security deposit for specific reasons such as unpaid rent, damage beyond normal wear and tear, or other breaches of the lease agreement. For example, New York State General Obligations Law subsection 7-108. Landlords are often required to provide an itemized statement of deductions from the security deposit, usually within a specific time frame after the tenant vacates the property. This is stipulated in many state laws, for example, Florida Statute subsection 83.49. Most states have a deadline by which the security deposit or the itemized accounting must be returned to the tenant. This can range from 14 to 60 days, depending on the state, for example, Texas Property Code subsection 92.109. The concept of normal wear and tear is critical. landlords, typically cannot deduct for normal wear and tear, only for damages that exceed this. Definitions of normal wear and tear vary, but generally include routine, gradual deterioration, referred to Illinois Security Deposit Return Act. In some jurisdictions, landlords are required to pay interest on held security deposits, referred to New York City Administrative Code subsection 26-11003. If a dispute cannot be resolved, tenants often have the right to sue in small claims court for the return of their deposit. Penalties for wrongful withholding. In some states, landlords who wrongfully withhold a security deposit may be liable for additional damages, sometimes 2 or 3 times the amount of the deposit. For example, Massachusetts General Laws, Chapter 186. Section 15B. Resolution steps. Check the lease for specific terms related to the security deposit. Document the condition of property. Both parties should document the condition of the property at move-in and move-out. Negotiate and try to resolve the dispute amicably through discussion and negotiation. If an agreement can't be reached, seeking legal advice or mediation may be the next step. As a last resort, litigation in small claims court or other appropriate jurisdiction may be necessary. The court referred to the Michigan Security Deposit Act, MSDA, outlined in MCL 554.601 to 554.616. According to the MSDA, landlords may deduct reasonable cleaning and repair costs but cannot charge for normal wear and tear. The burden of proof lies with the landlord to demonstrate the necessity of deductions beyond ordinary wear and tear. Outcome. The court ruled in favor of the tenant, Sarah, finding that the deductions made by Mr. Smith were excessive and failed to substantiate damages beyond normal wear and tear. Landlord Mr. Smith was ordered to refund the withheld portion of the security deposit to Sarah, along with applicable interest as stipulated by the MSDA. The case established the importance of landlords providing itemized lists of deductions along with receipts or documentation to substantiate deductions made from security deposits in Michigan. It emphasized the landlord's burden of proof to demonstrate the necessity of deductions beyond normal wear and tear. Thank you for joining us on this informative journey. To stay updated on landlord-tenant laws, tips, and real-life scenarios, subscribe to our channel. Knowledge is key in navigating the rental landscape. Until next time.